Good day everyone, my name is Jonard Escabusa. So for today's topic, me and my groupmates will tackle about the Financial Rehabilitation and Insolvency Act, Philippine Competition Act, and Government Procurement Law. So first, we will discuss about FRIA, or the Financial Rehabilitation and Insolvency Act of 2010. So what is FRIA? So it is stated there that the FRIA is to encourage debtors, both juridical and natural persons, and their creditors to collectively and realistically resolve and adjust com- competing claims and property rights. So it is targeted both corporate and individuals, and it helps every debtors to settle its obligation to their creditors. And it can also help creditors so that they can get the money that they lend to the debtors. It is a law that governs the rehabilitation and liquidation of the debtors. So who can apply FRIA? So the sole proprietorship, partnership, corporation, or individuals can apply or file a FRIA if they needed. It is, it is ensures that the debtors are rehabilitated or liquidated on time, fairly, transparently, effectively, and efficiently. While most of the companies or businesses have troubles with their financial status, no matter how big or small there is, or their company, sometimes they are not able to pay all of their debt. So if they're experiencing this trouble, the FRIA will help them to maintain or to restore the balance of their assets and liabilities by rehabilitation. So what is the meaning of rehabilitation? It is stated that the rehabilitation is the action of restoring something that has been damaged to its former condition. When they don't have any power to pay their debt due to insolvency, that's where the liquidation comes in. Liquidating. It is the process of bringing a business to an end and distributing its assets to claimants. In rehabilitation, there is two kinds. It's either voluntary or involuntary. So voluntary proceedings shall refer to proceeding initiated by the debtors, while the involuntary proceeding shall refer to proceeding initiated by the creditors. So always remember that the voluntary proceedings is for debtor, while the involuntary proceeding is for creditor. So who can file? Who can file a rehabilitation? So it says that the sole proprietorship, partnerships, and corporation with majority votes of the board of directors can file a petition to the regional trial court if they notice a problem with their financial status or having a financial insolvency. Who can file an involuntary rehabilitation? So it said that any creditor or group of creditors with an aggregate claim of at least 1 million pesos or at least 25% of the subscribed capital or partner's contribution, whichever is higher. So the main purpose of rehabilitation is to maximize the allotted time of the debtors to repay its debt to their creditors. The court also secures the creditor's right that they will receive the full payment of their debtors. So if you ask where to file a petition, so you should go to the regional trial court acting as a special commercial court. So the next one is the commencement order, the stay or suspension order. So it is stated there that the advantage of filing a petition in FRIA, the creditors will not bother you to pay off your debt right away because the court will provide extra time to pay your debt. But it doesn't mean that you have a right to sell or transfer your asset or your property. If you do that, if you do transferring or selling your property while the case is ongoing, there might be a possible of suspension of petition. Always remember that the Financial Rehabilitation and Insolvency Act of 2010 will help the debtors to pay their debt to their respective creditors by rehabilitation, but if they fail to restore their financial status, there will be a liquidation in their company.
Philippine Competition Act. The Philippine Competition Act (PCA) or the Republic Act 10667 is the primary competition policy of the Philippines for promoting and protecting competitive market. It will protect the well-being of consumers and preserve the efficiency of competition in the marketplace. Enforcement of this law will help ensure that markets are open and free, challenging anti-competitive business practices while maintaining an environment where businesses can compete based on the quality of their work. A competitive market means a market with multiple buyers and multiple sellers, driving market prices lower and offering consumers more choices. A truly competitive market encourages efficiency and innovation and forces businesses to excel. The Act reflects the belief that competition promotes entrepreneurial spirit, encourages private investment, facilitates technology development and transfer, and lastly enhances resource productivity. The implementing rules and regulations shall cover all mandated functions and duties of the Philippine Competition Commission to facilitate the implementation. Now, this act has 10 rules. Rule 1 is the title and scope, which has two sections. Which has two sections. Section 1 is the title. Section 2 is the scope. Sorry. Rule 2 is the definition of term. The following definition of terms shall apply for purposes of this rule. Rule 3 has three sections. Rule 3 is the Prohibited Act. Section 1 is anti-competitive agreements. Section 2 is the abuse of dominant position. Section 3 is the determination of exceptions. Rule 4 has 13 sections. Rule 4 is the mergers and acquisitions. Section 1 review of mergers and acquisitions. Section 2 is the notifying entities. Section 3 is the thresholds for compulsory notification, which is 1 billion pesos. Section 4 is the consultations preceding the submission of notification. Section 5 is the procedure for notification and review. Section 6 is the effect of notification. Section 7 is the publication of notification summary. Section 8 is the modifications to thresholds and compulsory notification. Section 9 is the prohibited mergers and acquisitions. Section 10 is the exemptions from prohibited mergers and acquisition. Section 11 is the burden of proof. Section 12 is the finality of rulings on mergers and acquisitions. Section 13 is the treatment of confidential information. Rule 5 has only one section, the determination of the relevant market. Rule 6 also has only one section, it is the determination of control. Rule 7 also has one section, the determination of anti-competitive agreement or conduct. Rule 8 has 5 sections. Rule 8 is the determination of dominance. Section 1 is the existence of dominance. Section 2 is the assessment of dominance. Section 3 is the presumption of dominance. Section 4 is the setting the threshold for dominance. And Section 5 is the exceptions. Rule number 9 has only 2 sections. Rule number 9 is the forbearance. Section 1, forbearance of the Commission. Section 2 is the public hearing. Rule 10, the last rule, has the final provisions, and it has only 3 sections. Section 1 is the revisions of these rules. Section 2 is the separability clause. And Section 3 is the effectivity.
Today, I will be sharing to you the review about the Government Procurement Act or Public Act 9184. But first, we have to define the term procurement. It is an action of obtaining or procuring something. Procurement refers to the acquisition of goods, consulting services, contracting for infrastructure project by the procuring entity. It also includes the list of goods and real estate. We have the legal basis, means we have the law in terms of the Government Procurement Act. It comes in the form of Republic Act 9184, or known as Government Procurement Reform Act. It is an act providing for the modernization, regulation, and standardization of the procurement activities of the government and for other purposes. So it's the same as either government or private. Under Section 2, the Declaration of Policy, it is a declared policy of the state to promote the ideals of good governance in all its branches, departments, agencies, subdivisions, instrumentalities, including government-owned, controlled corporations, and local government units. So the coverage as to will be covered under this law is also detailed. Under Section 3, the governing principles on government procurement. So these are principles that we need to follow when we do the government procurement. First is transparency in the procurement process and in the implementation of procurement contract. So this means we should be open and transparent with everyone. Second, competitiveness by extending equal opportunity to enable private contracting parties who are eligible and qualified to participate in a public bidding. So we must provide equal opportunities for all private entities to participate in the bidding. Third is streamlined procurement process that will uniformly apply to all government procurement. The procurement process shall be simple and made adaptable to advances in modern technology in order to ensure an effective and efficient method. So all unnecessary parts are eliminated in a streamlined process, and we should be adaptable to modern technology, and when it comes to procurement, we should be effective and efficient. System of accountability where both the public officials directly or indirectly involved in the procurement process as well as in the implementation of procurement contract and the private parties that deal with the government are, when warranted by circumstances, investigated and held liable for their actions relative thereto. So there's a system of accountability that makes the public officials liable in case there are circumstances that made them liable too. Public monitoring of the procurement process and the implementation of awarded contract with the end in view of guaranteeing that this contract are awarded pursuant to the provisions of this act and implementing rules and regulations, and that all these contracts are performed strictly according to the specifications. So there is a public monitoring system, procurement process, and award contract implementation, which we try to ensure that these contracts are really in line with what is specified under this law. The scope and applications. So this actually apply to the procurement of infrastructure project, goods, and consulting services regardless of the source of fund, whether local or foreign, by all branches and instrumentalities of governments. So department, offices, agencies, government-owned, controlled corporations, local government units, subject to the provisions of Commonwealth Act number 138. So any treaty or international or executive agreement affecting the subject matter of this act to which the Philippine government is a signatory shall be observed. So in short, this has many applications, and all branches, instrumentalities of their government should use and implement what is written in this law. So regardless of the resource of funding, whether local or foreign, so under Section 6 is standardization of procurement process and forms to systematize the procurement process, avoid confusion, and ensure transparency. The procurement process, including the forms to be used, should be standardized insofar as practicable. Procurement planning and budgeting. All procurement should be within the approved budget of the procuring entity and should be meticulously and judiciously planned by the procuring entity concerned. Consistent with government fiscal discipline measures, only those considered crucial to the efficient discharge of governmental functions shall be included in the annual procurement plan to be specified in the IRR rules and regulations. The penal clause under Republic Act 9184, the offenses and penalties. So any public officers, private individual committed any act or violations as provided in Republic Act 9184 have a penalties of not less than 6 years and 1 day but not more than 15 years of imprisonment. So this cover all types of procurement, whether manually or electronically.